Good evening, everyone.
Good evening.
Thank you very much for joining this session. Others are going to join us later. I know today is a Sunday. I was late by that, like 5 minutes, because I was talking to a lady called Sandra who has just paid. And I invited her. Her mom paid the full package just at 4 p.m. when I was about to start. And I said I will not leave her out. That's why I was delaying, so that to allow her to log in. So, Sandra, you can greet us and then give us your expectations, your preparation on by exams, and anything you want to say before we start.
Good evening, everyone. Thank you so much, Mr. Ngenya.
Yes.
My name is Sandra McKenna. I'm a current student at the Kenya School of Law. And I'm happy to have gotten this opportunity with such an organization or just someone who is conducting something with diligence like this for us students. My expectations are to learn deeper in terms of the revision and the drafting, because drafting has been a bit of a challenge for me, and also just doing the revision by myself. So getting a space like this I know it will truly help me grow, and I will learn how to answer questions also better. Yeah,
Okay.
thank you so much.
Sawa. After this session ends at 7 p.m., I'm going to activate you so that you view the papers.
Okay, thank you.
The papers from 2008. Then the one that I have not researched as the one we are dealing with them right now. And we started with conveyancing. Conveyancing, I had not researched October 2022 and March 2023. We started yesterday. We have dealt with question 1 and to 5. And we are going to start with question 6. Then we go to March 2023. This is an interaction. It's not a lecture. You prepare yourself well in advance. Student answer questions. So to say, do not feel shy or say these are long answers. What such kind of things? Say what it is in your heart, and we learn from each other. Not necessarily that I enjoy monopoly of knowledge. So yesterday, Ruth told me to start with this thing called quotients, inhibition, and restrictions. This is a very highly examinable area. In your Q&A, you see somewhere in the past they were asking about inhibition and restrictions and quotients. So on your screen you can see the Land Registration Act, Section 28 until Section 70 talks about inhibition. Section 71 until Section 75 talk about quotients, and Section 76 of Land Registration Act talks about Section 76 until Section 78 talk about restrictions. So these are restraints. These are restraints on disposition of land. This is the main thing you need to know. They restrain you from disposing the land. In another thing, there are encumbrances usually put on the land. So when someone, when there is a restriction, a caution, or an inhibition, that land cannot be transferred. Or yes, the disposition, they cannot be transferred until that inhibition, a caution, or restriction is removed. So the most important thing you need to know about inhibition, I usually put by court. And this, if you go to Kenya Law Report, you find a case, you may find one case that is dealing with inhibition. You can find one case because remember, in exams, if you are told about inhibition, you have to support it with a case. So in an exam scenario, when you told someone that moved to court and the court restrained, they will not tell you it is someone has moved to court about the land. They usually it is a dispute. It is a dispute. If you can see here, like for example, this is just an example you can put in your exams. Eri Jepkoech Rimo versus Susan Wangoi Kibe, and another 2020. This person, Eri Jepkosgei, moved to court saying that wanted an inhibition, saying that he had bought this land. And this person, before the transfer, the respondent was, they had a sale agreement, and he wanted to transfer to another person. So the court gave an inhibition. That was the ruling. So these are a good case you can put the, inhibition. So inhibition is by court. That is a different. That is a thing you must know. You know, and it is done by court, moved by someone, because court cannot move in itself. Caution we discussed yesterday. Caution, you lodge it at the registry if you have an interest in land. For example, you can choose to move to court for the court to inhibit. Also, you can put a caution yourself if you have an interest in land. Also, spouses who, if your husband want to transfer a land without involving you, can put a caution, and usually swear an affidavit. And in an exam scenario, you can be told to draft a caution and an affidavit. You know, in March 2023, they were told to draft a sale agreement. So, on your things to do, prepare, because now it's like drafting have come back. Teach yourself to draft a caution. A caution, and a caution also with you show an statutory affidavit. That is a very, very important document you need to know. We discuss how a caution is withdrawn. You can be asked in an exam scenario. A person who has lodged a caution, that is a section 73, can be withdrawn, or you can, if a caution is put against you, can also notify the registrar for it to be removed. So he called you the cautioner, then he hears you and remove, or you can move to court for a caution to be removed. That's another things you need also to know. And you need one case in an exam scenario. Go and find it, because you may be told that someone moved to court to remove a caution. So you need a case, and the section is section 73. Then restriction is done by the registrar. on its own motion. So restriction is section 76. And most likely he does this to prevent fraud or improper dealing. It does not need to be have moved by anyone. If when he's the registrar of front, when he sees that there's something fishy going on with a certain land, he can put a restriction. So the difference between inhibition, caution, and restriction is that inhibition is by court, caution is by the person, and restriction is by the registrar. And I hope that is clear. That is a highly examinable area in an exam, and you need to know those areas I've told you. Now we continue with our question. Have you understood, Ruth?
Yes, thank you.
Yes.
So we move to so we continue with our October 2022 question 6. Imani owes a property valued at 10 million. The property is charged at ABC Bank for 5 million. Imani has entered in an agreement to sell it to Penda for Kenya shillings 10 million. So wherever you hear that you are told in an exam scenario that property is charged, you just know that that is charged. And they are saying is valued at 10 million and the charge is 5 million. He has entered into an agreement to sell it to Penda for 10 million. Advise Imani on action and procedures to be undertaken to transfer the property to Penda. So Imani here is the seller or the vendor, and Penda is the buyer or purchaser. But there is a charge with to this property. These are facts you must understand in an exam. So what do you think, Marianne? 5 marks.
A charge creates an encumberment, so you can't really transfer unless you clear it. So I feel, first of all, they need to discharge the property. So I feel like Imani can write a professional undertaking to ABC Bank for the title document, so that he can for payment for the title documents in lieu of money, so that he can transfer the charge in favor of Penda, and then he'll use part of the purchase price to settle the charge for ABC Bank and discharge the charge. I think that's what I would do.
Ruth, do you have anything else to add?
No, I'll also do the PU.
PU, eh?
And then there's something I want to ask. When you say that you can charge a sale, right?
You can?
Can you charge the okay, you're writing a PU so that can be given a certificate, your title.
Yes.
So I'm wondering, is there now the sale itself? Can you? It's okay.
Sandra, what can you say?
On my end, I have nothing to add. I share the same sentiments with Miriam. Yeah.
Okay. So, the first thing is that if you are told to procedures, you know, when you're answering a question in an exam, you must procedure, you must date it sequentially. So the first thing is Imani we will hire an advocate to act on his to act as to act for her as the advocate. That's the first step. Of course, B talks about Imani advocates. Imani advocate to give a professional undertaking to pay the advocate. To be used to offset the loan with they first write a professional undertaking for the title to be released to be used to write to ABC Bank telling them that they have entered in a sale agreement with the Penda and they are going to use the title so that they release the title, and they, of course, the question says that the sale agreement has already been drafted, telling them they undertake to pay the 5 million after being paid by Penda. Or you can also say Imani advocate to give a professional undertake to Penda. Of course, the agreement will say that Penda advocate to give them 5 million to offset their loan to ABC Bank. In fact, that is the first thing. They give them a professional undertaking, telling them they have a loan with the bank. Of course, the agreement will say that to give them the 5 million so that they can offset the 5 million that is in the bank. So that is the first thing. And that one you earn 1 mark. Then Imani pays the loan to ABC and requests a discharge for charge. So after being given 5 million, then Imani, who is the seller, will pay the loan to ABC and request a discharge for charge. Then a discharge of charge, of course, you know, it is registered in the ministry, and there are stamp duty that is paid. I think it was 0.05%. Is it see that amount? Is 0.05%. This is a question you can be asked in an exam. Then Imani advocate get other required clearances and consents, including paying for stamp duty on transfer of the property and getting the discharge for charge. Then Penda advocates draft the transfer. You remember we said that the transfer is usually drafted by the buyer. Then both parties, and it is, of course, it is the Imani advocates, Imani advocate, the seller sign the transfer. Then they do the completion, where Penda will give the balance of the purchase price, which is 5 million. And then the Imani will give the completion documents, and we have already stated the completion documents in another question above there. So if you talk with that, if you talk about that process, you will have earned yourself 5 marks. And the most important thing here is 2 things. This question is these 5 marks. You must talk about 2 things: professional undertaking and discharge of charge to this property, because the transfer cannot be done when there is a discharge of charge. So those are very, very two important documents which you need to those are 2 things you need to say in this question. Then We go to the next question. Imani's advocate requires a Penda's advocate professional undertaking. What is a professional undertaking? Marianne, what is a professional undertaking?
It's a solemn promise by an advocate during the course of their practice or not in practice, or by someone in their employ to do something.
Yes, a professional undertaking. Ruth Mohoro, do you have anything else to add?
I'll just add the unequivocal promise to do something or not to do something, and it is binding.
Yes, you see the most important things there. The most important, when you're talking, you are told to define the professional undertaking. You must, the word that is very, very important there is the word that Ruth has said. It's an unequivocal declaration which is praised reliance, which another person's praised reliance on. And it is made by an advocate personally or by members of advocate staff, which advocate is personally bound. So if you are defining a professional undertaking, you must those 4 components. An equivocal declaration. After you have given it, you cannot revoke. Then it is someone relies on it, maybe another advocate or a client, and it's done by an advocate in the course of practice, either personally or by a member of advocate staff. In your Q&A, I don't know which year it was. I think you have interacted in a question that was asking a clerk gave a professional undertaking. Have you seen that question? It is there, and the question I think was asking if it was that was a binding professional undertaking. Yes, it was. Then it's bound the advocate personally, and that means that even if you change a law firm and you had issued a professional undertaking, you go to another law firm, it follows you there where you had gone. And which pleading does a person used to enforce a professional undertaking? This now is civil litigation. Sandra, pleading.
I'm not aware.
Okay, Marianne.
I've honestly forgotten. I know it and it's gone.
Okay, Ruth.
I think it's a notice of motion with a supporting affidavit.
No, it is you know, a notice of motion, you know, the notice of motion, there is an application. Notice of motion does not originate a case. They only come as they are in to do some things there inside. It is an originating summon,
Okay.
And that is a question you can be asking in civil litigation, even to draft, and write that down and practice to do originating summons and get a case law for purposes of both civil litigation and conveyancing. If you ask someone, an advocate moved to court and wanted to enforce a professional undertaking against another advocate, you have one case which you use both for conveyancing and for civil litigation. Then discuss the nature and rationale of professional undertaking. That is the next question. We have with that one. We have that one was 1 mark. This is now 4 marks, which I've already said. In some of the things that I've said there, you discuss them in the nature and the nature. The question is asking the nature and the rationale of professional undertaking. So you also say that undertakings are normally expected to be honored between the giver and the recipient. If you are writing, they are given by lawyers to smoothen and hasten the process of transactions. They create bridges without which a transaction can never be completed. Professional undertakings are used to create bridges which without transactions may never be completed. Then you can say also that when a lawyer is giving a professional undertaking, he must weigh whether everything is within his control and if he's willing to honor it. If you don't have control of everything, never give a professional undertaking. Then you can also say that an advocate should give express instruction to the members of the staff never to give a professional undertaking. So then you can also say that a professional undertaking is a disciplinary, it's an offense that an advocate can be taken to the disciplinary. I think also you have learned that in your professional ethics class. Professional misconduct. And then now say that an advocate the court can enforce a professional undertaking which is filed by the recipient or the person who relied on it to do something through an originating summons. And then in your free time, go to Kenya Law Report and get one case. What I've said, that case, you memorize it, cram it. You use it for both for civil and conveyancing. There is a case there that I think I've used in civil litigation that involved Abros Wenda, advocate. He was told to, you'll see it somewhere. That is one of the cases you can use. And this question of professional undertaking, it can be asked in professional ethics class, it can be asked in civil litigation, it can be asked in conveyancing. So all what I've said cut across all those subjects. So it's a very good area to study. Then we now go to March 2023 exams. Question 1. This paper was the most failed paper on the results that were released. It had 49% pass, and about 700 students failed this paper. Of course, it's because it had some new areas which have never been tested before, which we are going to look at. And that's why I was saying that in our last conveyancing class, we are going to do drafting and my predictions, areas that have not been tested, which may come. So the Q&A, the research help you look backwards. It helps you with the questions that have already been tested. You prepare well, but also look forward also. Question 1. Maseno Development Limited, herein referred to as Maseno Developments, have purchased a property from Patel. The property comprises of 1 acre of land in Jaba, Nakuru County, Nakuru City, Jaba Estate, and have been Patel's home for many years. Maseno Development would like to develop 50 high-end apartments for sale. Construction is due to commence in March 2023 and complete in December 2024. You have been instructed by Maseno Development to represent them in all the legal deliverables relating to the project. Now, just in to something that have come into my mind because of Sandra, I said, if you want to pass in conveyancing, you must know the following. These are the bare minimum you need to know. What is the interest in land? What is the question asking? What is the interest in land? Is it a freehold? Is it a leasehold? Is it a public land? Is it community land? Is it a lease where there's landlord and tenant? Is it a sectional property? Then charges. You must know the interest in land. Then you must know also the various processes, because after that you'll be asked the various processes. For example, if you want to transfer land, there are various processes: paying tax, change of user, clearance and consent, all those processes, which you must master and give step by step. Then those processes, you need to know them. If it is, for example, land, compulsory acquisition, all those things, community land, how do you to make a community land? How do community land, for example, come to be? The processes. If it is a lease, then you must also know the duties of an advocate, because most of the question will ask you the duties of an advocate. If you're acting for this party on this or that other party, what is for example, the duties of a chargeo or chargee advocate? What is the duties of a developer or buyer or seller? All those things, or landlord or tenant. Then you must also know the completion documents. So all those things, those are the bare minimum you must know in conveyancing for you to pass these subjects. If you know those, you'll be safe. Then the Land Act, land registration, you know the most important sections, because those are the areas. So because they usually say statutory provisions, Land Act, which is a substantive law, land registration, which is a procedural law, and land registration general regulation of 2017, which contains the forms or procedures. If you run, you get those three rules and regulations, you'll be good to go. And I think in our last class, we are going to look at the salient features in those laws. Then now we go back to the question. You have reviewed the title to the property and noted that the permitted use is single dweller unit. Discuss what your client should do to permit to develop multiple dwelling units. What do you think, Marianne? Those are 8 marks.
I think we're supposed to describe the procedure for change of user.
Yes, change of user. And change of user, you see now, change of user, this question now, you see now it has repeated itself from in change of user in October 2022. I think the question 1 which we dealt with, it was changing of user from agricultural land to commercial land. Now here you are changing from being a single dweller to a multiple dwelling units. So this is 8 marks. Can you try, Marianne? Continue.
So you had told us in the previous class, we have to, when we're answering these questions, we have to make reference to the statutory acts. And I think it's the Physical Planning and Land Use Act and the subsequent regulations. So first, I think we start with preparing, what do we start by preparing? We start by getting permission, I think, from the county. In this case, it's Nakuru County. So we get permission from the Nakuru County executive member in charge of land and physical planning in the prescribed form, which is PPA1, and pay the requisite fees that accompany the application. Then the application should also be accompanied by the owner's title documents, a comprehensive location plan, the planning brief, the master plan, and maybe a plan prepared by the surveyor. And then we can also attach we will also be required to have made an advert prior to in the local, in at least 2 local gazettes or dailies, and we will attach that also. And maybe we have also made like a notice that is usually affixed up the gate of the project. We'll also affix that. This is to ensure that there is public awareness and public participation about the project. And then we will, after forwarding our application to the county executive in charge of physical planning and land, they will review our application within 7 days and forward it to the relevant authorities, mostly the Ministry of Lands, for approval and recommendation within 14 days. Then, if there are no objections, the CEC will grant us the CC will grant us, I think, approval in Form PPA 2 within, I think, 30 days, and incorporate maybe the views of the public from public participation.
Sawa. That process is very elaborate. I think that one you earn 8 marks. The process is just the same. If you, in an exam scenario, if you are told there is a single dweller and they want to change it to become a multiple dweller, or you have been asked to change from agricultural land to the commercial land, the process is just the same. So note that one. If you are told to the property needs to be changed from agricultural to commercial, or commercial to agricultural, or from single dweller to multiple dweller, the process is just the same. What Marianne have just said. And this question also was question 2 in November 2021. 2A, which asked this. Ms. Penda has been, I can even project that one. I just want to show you how this question repeat themselves. It's not very clear. Ms. Penda has been in search of an investment of a 5 acres piece of land in Kiambu. Due to the scarcity of land, among other factors, she opted to put up a 40 apartment for sale. The title to the land, however, is indicated that she can only put up a single dwelling house. Describe the step that Ms. Penda advocate would endeavor to take to ensure that your client gets approval for construction of 40 apartments. So this land was a single dwelling. He wants to put 40 apartments. So it's change of user. So from November 2021, question 2A, it has repeated itself in, they only jumped April 2022 and October, then they came to, they have asked in March 2023, question 1. This one, they gave you 2 marks. Here they have given 8 marks. So this is a very, very highly examinable area. So master that process, change of user. You go to the next question. Maseno Development would like to understand how apartments are titled. The CEO attended our webinar on sectional property, but in Kahai is unclear how to proceed. Advise your client on process of issuance of sectional title to each apartment. So, Ruth, can you answer question 1A2?
Okay, just I think we had discussed this before.
Yes.
So the first thing is the mother title has to be your reference and approval.
Yes.
Approved by the surveyor.
Yes.
Department of Kenya.
Yes.
Second step is the sectional plan describing the units
Yes.
described by the surveyor by a building approval by the county government. Then the application of the sectional plan is lodged at the land registry for registration. So here the registrar index map amends the register. Then the application to register the sectional plan is accompanied by the management incorporation. The sectional plan is registered. The land registrar shall submit register to. I don't know what I'm writing here. I should. Okay, this one is not clear. Like in something about 21 days. Then the registrar closes the mother title and now make the separate sectional units registrars. They are registered separately. Then the certificate of title or certificate of lease, depending on the question, is issued for each sectional unit.
Very good. So this question, you have seen it has repeated itself. This question, we dealt with it. It was the same as question 3B of October 2022. And if these people are repeating questions that were asked in the previous paper, so also don't be surprised if they ask a question that was done in March 2023 in your November 2023 exams. And these were just 6 marks which you are free. So take note of that. Then we are not going to dwell with that so much. We did that. And now we go to the next question, question B. Erickson is a newly married to child sweetheart called Angie. They have been staying in Mihango in Utawala. He has decided to find an apartment in Laviton to live with his newly wedded wife. He has been asked to find a 3-bedroom apartment in Laviton owned by Arthur Johnson. Arthur Johnson, Arthur Johnson Sakaja lives in Ravington. That is on a lighter note. Arthur Johnson has agreed to sell Erickson, has agreed to buy the apartment for 18 million shillings. Erickson has made arrangement with XYZ Bank for financial accommodation of the entire agreed amount to enable him purchase this apartment number erected 85 erected on RIA number 1/19/537. Arthur Johnson have been referred to you by your former people master to handle the transaction. Arthur Johnson, you as Arthur Johnson advocate, proceed to draft the relevant initial legal document that will govern the relationship between Exxon and Arthur Johnson. So, Sandra, can you try that question? 6 marks. Sandra, can you hear me? Marianne, can you try?
Go ahead with Ruth first as I gather my thoughts.
Okay. I can. Ruth, what is your view?
Okay, according to the way I've understood, you're the one who's acting for.
You are
Arthur Johnson, who is the seller.
Yes.
Who is the seller? So this one, I think it is more on the duties of the advocate of a seller. So yes. Maybe it is all about capturing the sale agreement.
Yes.
Making sure the sale agreement is done. And then there's also for the 10%. Now, before even you do the finish, you do the transfer and everything, you have to get like the deposit. Now you'll have to
no, the question, yes, the question is telling you to proceed to draft. It's not this is a drafting question, eh? And the last time they asked about drafting questions in conveyancing was Kitambo. Yes.
In his agreement.
This is a sale agreement, which is, we say that the sale agreement is usually drafted by the seller's advocate. And what are the salient features that you must have in the most important things in a sale agreement. This is 6 marks, which you don't need to draft a very big documents, but there are those salient features that you need to have drafted. Can you tell them, Ruth, I'm still on you.
Okay, you'll have to have to the parties, you have to have the recital.
Yes.
You have to have that portion of, you have to go through LSK, condition of sale. You have to have the payment, like when the deposit and the full completion, time is of essence, close on that, and then
Yes.
okay.
Yes,
Yeah.
you. This on your screen, it is this is I just use this as an example. This is a student, the highest scored. It is in the CLE downloads. This student, you are the one who scored the highest in conveyancing, who had 42 marks, and we have already done question 1. So I go to question 1B. Question 1A and 1A1 and 1AB. So in your screen, you can see the parties, how you draft. This agreement is made on between Ada Johnson of P.O. Box, Laviton, a citizen of the Republic of Kenya, herein after record the vendor, and Erickson, a citizen of the Republic of Kenya, whose address for purposes of this agreement is P.O. Box Bra Bra, Utawala, Kenya. Herein after purchaser. Then you go to describing the property. Whereas the vendor is a registered proprietor for 3-bedroom apartment, number erected on land reference bus located in Ravito within the Republic of Kenya, the vendor is willing to sell, and the buyer is willing to buy in the terms. You recite the parties, then you describe the property. Those are 2 points. Then you go to the consideration. You state the consideration. Are they going to pay the 10 the consideration of sale and purchase of the property shall be sum of Kenya shillings 18 million. A deposit, of course, is from the question 10%. These are you become creative. Remember when I told you that in doing by exam document, that when you are drafting, you can add some facts, which does not necessarily change the question, to make your document beautiful. Then another very, very important another very, very important clause is completion. Completion. If you are asking an exam scenario, the parties, the consideration, you describe the property, the completion, condition of the completion date shall be 90 days from the date of this agreement. Then you say that, which I think this student missed, is that you must talk other very, very important clause is that you must talk about breach. What happened in case of breach by either party, and then that thing must have been signed. So in an exam scenario, if you are told to draft a sale agreement, which you are given 6 marks, you put those things, parties, description of the property, consideration, you can also put there before you come to completion. You can also put the duties of seller to go and get clearance and consent and also all those things. Then you come to breach, in case of breach, what happens? Then you finish with the completion. So things like governing law, those are not very, very important. Condition and warranties, we say there in the regulations, 2017 regulation says that the RSK condition for sale is automatically it is said it's automatically enjoined in a sale agreement unless there is contrary. So you don't need to put there. You can see in your screen. This is the Law Society of Kenya, Law Society of Kenya Condition for Sale 2015, which I shared in the group. This is a very, very important document. As I told you, you need to look at it. So agreement for sale is made on this day between blah, blah. Whereas, this is very, very important. I think they are called recitals. Now it's agreed as follows. You don't need to put, if you are given 15 marks, you can put the description of parties. But if it is 6 marks, you can description is not very, very important. The number of marks tells you how long the documents should be. If there are many marks, it is a lot of marks you have been given. For example, in civil litigation, compulsory 20 marks, you need to draft at least 3 documents. The pleading, maybe certificate of urgency, notice of motion, and affidavit. But if it is a question with 10 marks, maybe you draft a notice of motion and an affidavit. So the marks guide you. Then you come to the purchase price and deposit. Then completion. These are very important also clause, and you name the completion documents. The completion date shall be for 90 days, very, very important, and the completion document. Then, breach by either party. You can ignore possession and matters affecting property. Breach in case of either party. And you can look at how here you can say that if the purchaser failed to comply with any provision of this agreement to the detriment of the seller, the vendor can either give a notice to complete, or the purchaser continues to breach. You can forfeit. He can forfeit the purchase price. Also say the vendor, if the vendor is unable to complete, the purchaser can serve a notice and also extend the time of completion or rescind an agreement and demand compensation. Something like that. So then miscellaneous, read them, notices, read them, jurisdiction, You can put this agreement can be interpreted according to the rules of Kenya, and parties hereby submit to the jurisdiction of the court. Then, very, very important is the nini, the signature, the engrossing and all kind of things. So you must put this, the vendor's name and place to sign, the name of witness, and then this is very, very important, the signature for advocate. So because the vendor has his own advocate and the seller has his own advocate. I think this is, you can see here, this is what this student missed. He did not put the attestation by the advocate. Very, very important. It is in the law, Land Registration Act. I don't, go and investigate which section is that. And you can't miss that in an exam. So that one you must put attestation by the advocate, signing and those things, and you will have earned your 6 marks. We are going to do more drafting in our next conveyancing class. They have tested various conveyancing. In conveyancing, they have tested drafting. They have tested notice to complete. They have tested transfer. They have tested professional undertaking. They have tested. So we are going to deal with those things in the next class. So prepare for that drafting.
I have a question, Mwalimu.
Yes.
As well. Is there a difference between jurisdiction clause and this governing law and
Governing
law? Yeah, is there a difference and to do arbitration and dispute resolution?
You see,
because here she's using governing law and dispute, but I've seen in the sales agreement jurisdiction.
Yes, ndio nasema, you see, governing law and dispute resolution, you usually find them in arbitration clause. But for the purposes of exams, governing law, it is a governing law. It is of course the sale argument is governed by the laws of Kenya, but for purposes of exams, say you put jurisdiction, because these Royal Society of Kenya conditions are the one. These are the, remember we say that they are in the law, they are in the general regulation. So this, instead, in an exam, you don't say governing law and dispute resolution, you say jurisdictions. What I've just said here, the agreement shall be interpreted according to the laws of Kenya. And parties submit to the jurisdiction of courts of Kenya. So use jurisdiction and put this clause. Sawa sawa. Are you together? Sawa. So that internalize that document called the Royal Society of Kenya Condition of Sale. You must use it in an exam. That one I assure you. Every exam you must, because every exam must contain somewhere there is a sale agreement between buyer and seller. So you must use it somewhere. That is I can tell you this is a the sale of land is a compulsory question in conveyancing. And that also means that the Royal Society of Kenya condition for sale is a compulsory. You must use it somewhere. You can't, that's why I was telling you, that is one of the things you must understand. So we go to the next question. Drafting is a skill. You practice, and practice. You cannot read theory and cram. You practice both substance and procedure. And the question is 6 marks. So this is a question you use like like if I told you compulsory question of 20 bucks, you use 50 minutes. This one you use like you divide by 3. You use like 15 minutes to draft. So it must be very fast. So we go to the next question. Question 2. Prime Property Limited is the registered owner of leasehold property. So the of course leasehold are in the city. You know that leasehold are in the city, freehold are outside the city, known as ARA 500-12998, located in Nakuru City. The property is located in a busy part of town and developed well fast with barbed wire. The annual rent, you saw every time you see annual rent, known as a leasehold. Is peppercorn on demand. There is a time for 99 years from 1st November 2021 to 2001. The company approached by Albert to propose to utilize the said property as a parking lot. The company approaches you for legal advice on transaction and has informed you as follows. The company is hesitant to have the use of defined premises for a period of excess of 1 year, but may subject to renewal of similar terms. The company prefers Albert to collect daily parking fees and deducts an agreed commission fee for revenues collected. The company prefers that Albert maintains the parking lot in good condition for the entire period, like he keeps proper records or books of accounts at all times. So, to understand this question, Karibu Helen. How are you?
Asante, I'm well.
Okay, sawa. So, if before even you before you read what the question is asking, so this company, this company which own this property have been approached by Albert, which want to utilize the said as parking lot. So if you are told that way, then the other details. What do you think the question is leading you to? We are going to start with Marianne.
I'm not sure. I feel like this is an estate agent, or that's the work Albert is supposed to perform.
What is an estate agent? When you see the company have been approached by who proposed to use the said property as parking lot. So remember, this property is not developed, and this person has come. He wants to use it as a parking lot. Don't you see that there is a clue there? The question is leading you to something. Then all these other details here that have been put. Can we go to Ruth? What do you think?
Because of the 1 year, I think it's a license.
Yes, the question is asking you about your knowledge on leases. When you know this question, you know, this person is not buying. So of course, this is not a seller and a buyer. So you want to use it as a parking lot, and it is an undeveloped land. So this question already is already leading you. It is what it want to test you on leases and licenses, because where there is a landlord and a tenant. So you can only leases and licenses go together. So that is a clue for that thing. Then there's these other details. The company is registered to have the use of defined premises for a period in excess of 1 year, but may subject to renewal of similar terms. The company prefers Albert to collect daily parking fee and deducts an agreed commission fee for revenue collected. Then the company prefers that Albert maintains parking lot in good condition. When you hear that good condition for the entire period and keep good records, you know, one of the duties of someone who are tenant is to keep the property in good condition. You have learned maneno ya leases in your classes. Have you reached there? Have you reached there, Nani? Ruth, have you reached there? Maneno ya landlord and tenancy.
Yes.
You have done, eh?
Yes.
And the duties are both for the landlord and the tenant, and are there in the, I think, Land Act and yeah. So that's why I'm saying you must you internalize the Land Act and Land Registration Act. If you put them in your fingertips, you can answer any question, because they usually say you quote the law. You may not remember the section, but you say in the Land Act it says this and this. Charges are in the Land Act. So the first question, as way two possible ways you may consider the structuring the transaction between property and Albert, noting the pitfalls of each one of them in protecting the interest of the company. So how you may structure with all those details. Sandra, what do you think? Helen, what do you think?
Mwalimu,
Yes. Yes.
is this where we look at either, is it either a sublease or a license?
That is Marianne.
Yes.
Helen seems to have gone and out. Yes, this is the question is tested. It is you structure it as it can be structured either as a lease or a license. So that is you define what is a lease and also what is a license. And noting the pitfalls of each one in protecting the interests of the company. So which are the pitfalls of lease and license? When when here, remember the landlord here is the company. The pitfalls of each one of them towards the company. You can try, Mary, and continue.
So at least you grant exclusive ownership, so you can't interfere. But then the license is more of like used to, is like permission to use the premises. So like you as the owner of the property could always come and inspect. And then with the lease, if you grant them a lease, they could always transfer or assign it to someone else. But then a license until termination. And then at least it's hard to revoke. So in the event of a disagreement, like you might not be able to do away with it easily. But then like a license is easily revoked as long as there's reasonable notice. And then, yes, those are the ones I know.
Very good. This question was, that's how this question, it wanted you to define the risks and licenses and compare advantage, because licensee is where they are saying that he's given what they are saying there, that daily parking fees and agree commission, that is a license. But when they maintains the parking lot in good condition, that is a license. And the pitfalls are what Marianne have just discussed. And is anyone can anyone add something else? If you have anything to add. So, at least grant priority of the land, exclusive possession of the property, while the license does not. So you can write that. And Section 2 of the Land Act defines what is a lease. You can look there later, Section 2. And a lease is not easily terminated for any reason other than breach. So that is another point. But a license can be terminated for any reason. Provide you give a reasonable notice. So, if you look at question 6 July 2019, question 6B. It is the last time the comparison between lease and license was examined. So that tells you that they went back to 2019. You can also say that in lease, the interest is registrable if it is for more than 2 years. But a license can only be registered at the Registration of Documents Act, which does not confer much protection. Now, explain, we go to the next question, and there you earn your 4 marks. Explain how would you go about the transaction to ensure that it's not a controlled tenancy. Jerry, what is a controlled tenancy?
We have not covered that,
Yes.
but I would say that there are restrictions in a controlled tenancy, but we have not covered that yet.
Okay. Okay. Anyone who can try?
I can try. This is a tenancy for less than 5 years.
Okay.
And I think the governing law is when it comes to commercial property, it is the landlord and tenant, and then into bracket hotel, another 2 into bracket. Then if it's a residential, I've forgotten the whatever, but now there are 2 tribunals where you go to either rent tribunal for residential or the I've forgotten some things. Fine.
So a control tenancy is defined in that act of that act that Nani Ruth have said. I think it's section 2. And can someone download? Can someone Can someone download that act?
The Landlord and Tenant Act.
Yes. And read for us that section 2. How it defines it's defined how it's defined the conveyancing, the controlled tenancy. You just go to Kenya Law
Okay, let me read.
Yeah, Kenya Law Report website. You can read.
Okay, control tenancy means a tenancy or
it means
continue.
Continue listening.
Oh, okay. Control tenancy means a tenancy of a shop, hotel, or catering establishment, A, which has not been reduced into writing, or which has been reduced into writing, and which A1 is of a period of not exceeding 5 years, or contain provision for termination otherwise than for breach of covenant within 5 years from the commencement thereof, or it relates to premises of a class specified under the subsection 2 of this section, provided that no tenancy to which the government, the county, the community, or a local authority is party, whether as landlord or as a tenant, shall be a controlled tenancy.
Yes. So a controlled tenancy is what Nani has just said. Section 2(1) of Landlord and Tenant Shops, Hotels and Catering Establishment Act. Controlled tenancy is which has not been reduced into writing. That is one. Or which has not been reduced in writing, which has been reduced in writing, which is for a period of not exceeding 5 years. Or which provisions of termination otherwise than breach of covenant within 5 years. 3 relates to the class specified under section 2 of these sections. So, if that is a controlled tenancy, and the question tells you, how would you go about the transaction to ensure that it's not a controlled tenancy? How would you answer that question? Looking at the definition under that act, that act, section 2 of landlord and tenant, landlord and tenant, shops, hotel, catering establishment, which this section 2.1, the definition of controlled tenancy, you need to have memorized these features, the definition itself. So looking at that definition, what do you think to ensure that it's not a controlled tenancy? So how would you answer this question? We are going to start with Marianne. What would you say in that question?
I would make sure that either the license or lease agreement is an oral agreement, or if it has to be in writing,
Yes.
that it is for a period less than 5 years, or it contains breaches of termination other than breach of covenant.
No, the first thing is it is correct, which is you make it oral agreement. You don't put it in writing. Then it's not for a period exceeding 5 years. So you make the second point is that you make the if it is in writing, you make the agreement, the tenancy agreement, to be for more than 5 years, because it says that controlled tenancy is for a period exceeding 5 years. Then that is the second point. So you can make it 5 months and 5 years, 5 months, 5 years, 1 month, 6 years, 7 years, bora iwe more than 5 years. Then this is a provision that gave me a lot of problem to interpret it. Contains a provision for termination otherwise than breach of covenant within the 5 years from the commencement thereof. So this one I will not point anyone. I want you to think, what does it mean? What contains provision of termination otherwise than the breach of covenant within 5 years of commencement thereof? Can someone try to interpret for us what does that mean? According
I
to
can
you.
try.
Yes.
That this first that this agreement is written, and then in this written agreement we have a clause that says that we can terminate the agreement anytime before the close of, so within the first 2 months, within 4 months, within 2 years, within 3 years, there's a clause that says we can terminate. You see,
Yes.
termination for 2 reasons.
Yes.
For breach of contract, the law allows you to terminate any time. But
Yes.
for any other thing that is not a breach,
yes.
You cannot just go terminating it anyhow unless the contract so agrees. So
Yes.
if the contract you are doing or the agreement you are doing allows you to terminate in the 2nd year, in the 3rd year, in the 4th year, but not for a breach of contract, for any other reason. Like you say, I don't want to continue and I have given notice, so you are allowed to terminate it for the lapse of 5 years, then that is what it is speaking to. No,
Yes.
that is the 3rd reason.
Yes, I think that is a very good interpretation. that is another good thing that what Jerry is saying. And I think if you give those three things, it's not reduced. You make it oral, you make the agreement you make the agreement for the controlled tenancy for more than 5 years, then what that Jerry is saying, and you have answered that question. And
excuse me, please.
Yes.
I kind of seem lost. Now, there are two things we are trying to understand here. What a controlled tenancy is. I'm sorry, I have someone here who is assisting me read. Keep quiet.
Don't worry.
We have a controlled tenancy, and then our question is asking us to ensure that we don't enter into a controlled tenancy, right?
Mm-hmm.
So for a controlled tenancy, the first requirement for it to be a controlled tenancy is that it is oral.
Yes.
So
no.
We are saying it cannot be oral, so that it doesn't fall into the realm of a controlled tenancy. So I'm saying like we are confusing those two things.
No, you see,
Mm-hmm.
I want to share the screen so that you say you see what the meaning of the controlled tenancy.
Yes, yes.
I want to project the screen.
Okay.
My laptop inaanza kufanya hivi, lakini I hope it will not bring any problem.
Okay.
Shaking. Your screen is loading. So I think you are now screen sharing. So you can see.
Yeah, we can see.
Landlord and tenants, shop, hotels, and catering establishment. Cap 301. You need to know this section. This is a question that is asked. So under interpretation, this is a controlled tenancy. Means a shop, hotel, or catering establishment. So it means which has not been reduced in writing. So if you want to put the question is asking you not to put the nini. The nini is not in controlled tenancy. So you put it in has not been reduced in writing. No. So you reduce it in writing.
No. Okay, sorry. They are saying that a controlled tenancy means a tenancy, shop, hotel, which has not been reduced into writing. So if it is oral, it is controlled.
It's controlled. It's controlled. That's what I'm saying. If it is oral, it's controlled.
Yes.
No. So
yes.
the first answer to the question is the agreement between this Albert and the company should be in writing. Are we together?
Agreed. Now we are together.
We are together. So the first, the controlled tenancy is the one which has not been reduced into writing. Then, so for the first point there is reduce the agreement into writing. Then, which has not been reduced in writing, which has not been reduced into writing, and which is for period not exceeding five years. So, if you want, also the next point, if you want to put it not in controlled tenancy, you reduce it in writing, but also you put it for a period more than 5 years. Are we together, Jerry?
Yes. I'm following.
That is another point. So
yes,
that is the second point. The first point is that it is written. The second point is that it is for more than 5 years. And you compare what the control tenancy says in your answer. Then the provision 3 is what B2 is what gave me problems. Interpreting contain provisions of termination other than breach of the covenant within 5 years from the commencement thereof. Otherwise than breach of covenant. Does that mean that if you want to put it into to remove it from controlled tenancy, you put a breach of covenant as the only term that can make you can only term that can make terminate the tenancy? Or what is your interpretation, Jerry? Now see what you are saying.
My interpretation is that the clause will say that this agreement will not be terminated before the lapse of 5 years. May not be terminated before the lapse of 5 years unless it is for breach of contract. So saying that you can only terminate it after the lapse of 5 years. This provision is tied to the second provision that is talking about that the period must not should be 5 years and above. So for a controlled tenancy is 5 years and below. So to make sure that it does not become 5 years and below, that is how this other provision is coming. So that we are saying that if it should not be terminated before the lapse of 5 years, unless it is for a breach of contract. I know it is not easy. Hata mtu anakaa anajichanganya, but that is how I'm understanding it.
So if you want to now in long and short, if you want to for it not to be in controlled tenancy, what would you say in your answer? Not for it to be we can see what is said for controlled tenancy. If you wanted to bring it out of controlled tenancy, what would you say?
I would say that the provision for termination will only be that it can only be terminated after the lapse of 5 years. So hiyo tenancy lazima ikuwe imeendelea for 5 years ili ikuwe terminated. So hauwezi terminate in the 3rd year, the 4th year, the 5th year. Unaweza tu terminate from the 6th year.
Yes, because it is saying otherwise than for breach within 5 years. So you put it outside the 5 years, the breach. Sindio? The termination of breach after 5 years. 5 years. So I hope the other people have the other students wamesikia hiyo. It gave me a lot of problem to interpret this, and I think Jerry has tried. And this question also was asked in, if you look at question 2B, April 2022. It's asking you, draft 2 clauses to be contained in legal document A above, so that to remove the transaction from the realm of the controlled tenancy. So you see what I said there, but of course, in light of what Jerry have said, I also add something there. Because that course also gave me a lot of problem to interpret. You see, you know, another thing. There's someone who was telling me they usually set these theory exams. He was telling me that a question is most likely going to be repeated if the candidates did not perform well. So I think if you look at this April thing, they asked this the same question. So they jumped in October, then they have asked in March. And I can assure you it is not an easy question. And don't be surprised if they repeat it in future. And that is the answer for that. So we continue. Albert requires that the rate clearance certificate be furnished to proceed with the transactions. Advise your client on import of this statement. So Albert wants a rate clearance certificate. So you are being advised, advise your client, who of course is the seller, the company. He wants a rate clearance certificate. What do you think? We go to Sandra. Sandra, you have not spoken. Helen, what do you think? Ruth, what do you think? Ruth Mohoro.
Please project the question.
Oh, sorry. Sasa. Let it load. But this part can now see. So C is saying Albert requires that a rate clearance certificate be furnished before he proceeds with the transaction. Albert anataka rate clearance certificate to be furnished by the company which is leasing. Advise your client on import of this statement. What do you think?
Okay, can you get a rate? Okay, me, I don't know, but I'm wondering if it's going to be given. Maybe if it's leases, I don't know.
Marianne, what do you think?
I know that rates are given, the clearance is given by the county government.
Mm-hmm.
So they may, I'm not sure if an evaluation is required so that they establish the rate charges. But that's all I know, that it's given by the county government.
Okay, nice trial. And Jerry, what do you think?
So when we talk about rates, we are talking about freehold, and as it has been said, it is from the county government. But beyond that, I'm wondering what it is they want us to decipher at the import of this statement. The import is that the land is a freehold. That is the only thing I can say.
No, the land is leasehold.
Oh, is leasehold?
Yes. The land is leasehold.
So for leasehold, we usually get rates. It's not rent.
Rent you pay to the government because it is a lease, but also rates you pay on leasehold. But there's something this question is testing. I think this question is testing this when you're doing a lease, a short-term lease, because you are told this for 1 year, it does not need to be registered. And also a license agreement. Do you read the pay rates when you are it is a lease? If someone wants to lease your property, or you are giving him a license, and it's for 1 year, do you need really to write clearance that is needed when you are registering? Do you need to register?
No, I think you only need it if you're registering the transfer, not like a short-term one that doesn't even need registration.
Yes, so that is what you are supposed to say for this question. You are supposed to say that rates clearance certificate are used when you are registering or when you are transferring. These are short-term lease, which does not need for 1 year, which is does or license, which does not need a late clearance certificate because it's not a transfer. They just need to enter into an agreement and go and register it under the Registered Document Act if it is yes, because it's a short-term lease or a license. So you say all those things, and you are going to earn your 3 marks.
Mwalimu, you said that the short-term lease, you enter an agreement and register in the
Registered Document the Registered Document Act in the ministry, short-term lease of more than the lease that you need to be registered is for more than 2 years. This is a short-term lease of 1 year. The question is telling you that 1 year here, or it is also a license. Those one you don't need for rate clearance. Only a lease from 2 years or a transfer, which you need to rent clearance. And that is what the question was testing you on. So we go to the next with the next question, question 3. I think we have another 1 hour to go. If today want us to finish today. So Andrew was born and raised in Butere County. While growing up, he noted that mothers and their children travel many kilometers to seek medical care. Medical care. Question 2C. This question I told you, this one has not been tested before. It's good to note that this was the first time it was being tested. Then we go to question 3. Andrew was born and raised in Butere in Kakamega County. While growing up, he noted that mothers and their children traveled many kilometers to seek medical care in various places, include Kakamega, Mumias, and Bukoma town. Sadly, some patients die on their way to the hospital due to poor road network and long distances. He has, in his prime age, partnered with American friends to set up a state-of-the-art hospital in Butere, where the residents are mainly sugarcane farmers. He has done this to alleviate the plight of residents of Butere. He has identified a 50-acre parcels of land owned by cane farmers that he would want to use to set up the hospital. You have received instruction from Andrew to advise on his, the transaction. So you have noted that 5 farmers. You are now, what I told you, you are the duties as an advocate, either for seller or buyer. It is a very common question. So Andrew want to buy this this land from these sugarcane farmers. Then you have noted that 5 farmers lost their title deeds. Advise Andrew on the process we follow to obtain lost titles. These are very straight. It is. You don't need to think. The question is telling you. It is telling you what it is testing you on. Advise Andrew on the process you follow to obtain the lost title. So someone can try. We start with our order here, which I've written. Marianne, can you try? What is the process?
I don't remember. I know I've written it down somewhere, but I don't remember.
Okay. Ruth, can you try that one?
Yes. The first thing, the 5 farmers will go to the police station, report this matter and get an OB. and maybe even an abstract. Then after that, they should go to, according to what I remember, I should go to the land registrar. I know, first of all, and report, those titles will first be advertised in the Gazette, just in case there's anybody who has an issue. If there's no issue, I think they're going to be returned, given back, something like that. Or is that a loss of a file? I don't know.
Sorry?
I don't know if I'm describing when your file is lost or when your title is lost. The one for gazetting.
Yes, you gazette. Can you repeat again?
Okay, the first thing you report in the police, or you get an OB and also an abstract, and you go to the land registrar with those ones. Now, there is one, I don't know if this is where your file is lost or your title is lost, where it has to be gazetted.
Yes, the registrar gazettes that the person has lost the title, and if he receives no objection from anyone, he gives a new title. So that's a good trial. I want to give you the process here. This question was last examined in question 5, July 5B. You can look at it later. 5B. So the process is as follows. You can write. First of all, those people must first of all make a statutory declaration. Saying that they have lost their title deeds. Then you prepare an advertisement in the newspaper saying that the title has been lost. They have lost their title. When you're looking those in the newspaper, you will see those things. The advertisement is placed in the newspaper for at least 7 days. Then, after expiry of 7 days, the advocate will make an application to the registrar, attaching the advertisement, the statutory declaration, of course, the statutory declaration will say the circumstances that the title, how they lost their title. Attach copy of PIN and ID. And for purposes of exams that is coming, you may be asked to draft a statutory declaration for a lost title. Of course, in a question, they will not tell you that is the thing. They will give you a story there. Someone lost a title, blah, 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 blah. They want to initiate the process of getting the lost title, draft the thing. So they will not tell you such statutory declaration. They will give you a story. So these are the things you must know and also know how to draft. Then The registrar then advertises in the Kenya Gazette. To effect that the persons have applied a copy of the title deed and invite objection in writing within 60 days. Last but not least, if the registrar does not get objections after the expiry of 60 days, it gives a duplicate title. And that is a process. For purposes of your legal writing and drafting class, you can be told to draft a gazette notice. You know that. Look at the legal writing and drafting questions. You see, you can be told to draft a gazette notice. And in this case, you can be told to draft that one. You can be told to draft, you are the registrar. I think even there is a question like that. You are the registrar of lands. You draft what I've just said, inviting people for objection. And Kenya Gazette, you can see on your screen. This was the Kenya Gazette for Friday, 8th September. It has all those things. For example, you can see this one. Whereas Michael Gedenji, blah, 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 of Puyo Box is the registered property of blah, 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 frat and by erected on the piece of land in the city of Nairobi, by virtue of this registered blah, blah, whereas the sufficient evidence have been shown that the lease have been lost. Notice is given at the expiration of 60 days. I shall issue a provisional certificate, provided that no objection have been received. Then you date, then registrar of title. So that is it. Issue a provisional certificate of title. You can see this. So there are so many. That is a question. You can be told to draft a gazette notice if you are the registrar of land, but not in conveyancing. Conveyancing, they cannot ask you to draft this one. It most likely you can be asked in your legal writing and drafting class. So we go to the next question. Those were 4 marks. You go to the next question. You have received instructions from Kenya Commercial Bank to recover a non-performing loan by selling land, usually as a security for loan via auction. What are the considerations you take into account when instructing an auctioneer to carry out the work? So this question is B, it's not related to A. So you have been told you have received instruction from Kenya Commercial to recover a loan, performing loan, non-performing loan by selling land. You said security. for loan via public auction. What consideration would you take into account in instructing an auctioneer to carry out the work? So, what do you think, Sandra? Speak. I know you joined us today, but you can speak. Helen, what do you think? Jerry, what do you think?
I think they're testing us on the provisions of Section 96 that says about the process that we're supposed to follow before an auction is given. So I would state the period, the notices that are supposed to be issued in the periods. I remember the total number of days is usually around 248. So there's a 45-day notice, there's a 90-day notice. I will need to refer back to Section 96, but I think that is what they're testing us on.
Yes. You see Section 96, Section 96, usually test on when they have exercising power of sale, when they have already reached selling the exercising power of sale of charged land. That is Section 96. Already they have reached there. But this question, which is a very, every time you are being asked a question where a sale of property which is charged, and this is a question that comes almost like in every exams. They are before even you reach to sale, they are testing you because the question is telling you that you recover an non-performing loan by selling. You see, selling the land. So before even you reach the nini, you need to talk what we discussed even yesterday. What Jerry have just said. Serving the notices. So you say that Section 91(1) of Land Act, the chargee needs to issue a statutory notice. Which must run for 3 months.
Mwalimu, I have a question.
Yes.
As you continue.
Yes.
I thought you would have done the procedure in part 2. Part 1 is the consideration while instruct. Okay. I'm not understanding the difference in how you'd answer part A and part B, because I think I would have done procedure in part B. Then in part, because I thought now in part B is where we do the notices with the timelines up to even the auctioneering notice. And then I don't know now in part 1 what we would be answering also.
Let me answer you. You see, that's why I was telling you, in an exam scenario, you must read very careful. And also underline the most important words. And also read all the question so that you don't answer for this part, you answer for this part. And for this part, when you go there, oh, you realize that you have already answered there. You take your time. Don't be too quick to read, to write this answer for this answer. So, you are told you have received instructions to recover a loan non-performing by selling land that is used for security for loan via an auction. What considerations would you take into account in instructing an auctioneer to carry out his work? Then advise on the steps your client and auctioneer are required to take to ensure the intended process is regular. Before you had been told that this person wants to sell. So you discuss the notices in question 3, in the first question. Then, because you just look if they issue the notices. Otherwise, the sale cannot continue. It become irregular. So that is what was being tested. And also look at if the auctioneer is licensed, and some other things that are contained in the Auctioneers Act. But when you come to steps, when they are now they're selling, you now discuss Section 96. When they are selling, fetch best value, blah blah, all those things in Section 96. So that is how I could have answered this question. So I would say you ensure that you look if the bank, before they do the sale, they have done the notices, which I was explaining. The notice served should have informed the nature and extent of the default. And they ought to have given him time to rectify. The notice will say the nature and extent of default, the amount which need to be paid to rectify the default, and a statement that when default is not rectified within a specified time, the charge will exercise his statutory power of sale by selling. So under Section 93 of Land Act, they are given 90 days. After service of the notice, before you sell the charge rate. So then you come to question 2. Of course, in one you can say they will check if the auctioneer is licensed, whether it's good, if of good standing. Because if you are not in good standing, you have no disciplinary cases. You cannot give that an auctioneer. Good license, good standing. Those are the initial you take into account when you're starting an auctioneer. Then you come to section, the second question. Then, here, you now incorporate the law of auction. And the auctioneer must advertise. And you can also say that you can say that Section 96(2) of Land Act, before exercising statutory power of sale of charge land, the chargee shall serve on the charger a notice to sell in prescribed form and shall not proceed to complete any sale until 45 days have elapsed. Then section 96, the notice should be served to various people mentioned there. Most important there is any guarantor of money. You know, you are still giving them time to redeem. Then the auctioneer must ensure that there is a forced valuation. It's undertaken the value. That is section 97. Then say that by fall of the hammer, you know, the auction, after advertisements, getting the bids on the day of advertisement, you must fetch the best price. The best bidder, the highest bidder, they usually say the highest bidder by fall of the hammer.
when does the auctioneer do the advert for auction? Is there a timeline for that?
I need to that one. You can look at your Nini. You can look at your. You can investigate on that. I'm not sure about the timelines. Go and investigate the process of the auctions. The time for advertisement, but the most important is advertise, get the highest bidder, and at the day of advertisement, get the by fall of the hammer, get the person who is the highest bidder. So this question was 3 marks. And I think having answered that way, you would have answered the question well. So my homework for you is go and read more on auctions. How auctions are conducted. That is a question that can come as even as a compulsory question, 20 marks.
She can look at regulation 15.
Mm-hmm. What does it say?
She can look at regulation 15 of the auctioneers. I read when I look at you. When it comes to immovable property, upon receipt of a court warrant or letter of instruction, the auctioneer shall, in the case of immovable property, A, record the court warrant or letter of instruction in the registrar. B, prepare a notification of sale in the form prescribed in sale form 4, set out in schedule 2, in second schedule, indicating the value of each property.
Mm-hmm.
Each property. Mm-hmm. Okay, I don't know. When you say so, I continue.
Continue. So, notification of sale, that is the most important thing for this question because it has not gone to court. So it needs to the auctioneer needs to prepare that notification of sale. Yes, you can continue. Which are the relevant section can you see there?
Could I continue there with what? Okay, well, part C, locate the property and serve the notification of sale of the property on registered owner. Mm-hmm. Or adult member, family, residents, or working with him, or where a person refuses to sign such notification, the auctioneer shall sign a certificate to that effect, give in writing to the owner of the property a notice of not less than 45 days. This is where the 45 comes in, within which the owner may redeem the property by payment of the amount set forth in the court, a warrant or letter of instructions. On expiry of the period of notice without payment, arrange sale of the property not earlier than 14 days after the first newspaper advertisement. So then regulation 16 is where you'll see the advertisement.
So if you look at section 98(1)(e), it says public, if a chargee or receiver is entitled to exercise power of sale, that sale may be by public auction with a reserve price. A reserve price is a price at which the value cannot, years end below that, the property cannot go this below. Then if you go to also to section 98(2) of Land Act, and I want to read it for you. If a sale is to proceed by public auction, it shall be the duty of the chargee to ensure that the sale is publicly advertised in such a manner and form as bring it to attention of persons likely to be interested in bidding of the charged land and the provision relating to auctions and tenders of land. So you also, this point is also emphasizing on public advertisement. Si unaonaga kwa gazeti auction zinakuanga sana sana Monday's newspaper. Look tomorrow, kuna auctions mingi sana, and there is some reserve price, which is reserve price ni ile price hii property yezi uzwa below this. And then during the day, you say that the highest bidder, the person who bid the highest at the fall of the hammer, is the person who gets to get the property. And that you have earn yourself the marks that is required there. So we go to the next before the time. So you go to question 4. Kim, the Kim family has lived in Bora Estate in Nairobi for the past 6 years. Having bought the house through partly family cash savings and partly by way of loan from Baraka Housing Finance. Mr. Kim was speaking to a colleague at workplace, land and titles in most parts of Nairobi, including Bora Estate, are being converted to new form of title and that the process is time-bound. The Kim family has approached you asking you to understand the nature and requirement and what they should do to comply with the same. So, the question A. What would you do to establish whether Kim's family title requires conversion? And what is the basis for conversion?
I can make an attempt.
Yes.
The basis for conversion title is pursuant to the Constitution of Kenya 2010 and the registration that followed thereafter, the Land Registration Act. Before the Land Registration Act, we had different regimes of registration of documents. So in pursuant to now the new provisions, all titles are supposed to be in line with the provisions of the Land Registration Act. So I would say that is the basis. And then for them to identify whether this land is should be converted, the procedure is that the parcels of land that have to be converted have to be gazetted. So it find out that land has been gazetted. It has been gazetted, then they will need to follow the process required to convert title. And as at now, the ones I know have been gazetted are the Nairobi parcels and Thank
Nairobi?
You. The Nairobi, the one calling and the registry that was formerly known as the principal registry in Nairobi.
Yes.
Yes.
Yes. I hope the others have heard that. That is a complete answer. So I will not add anything. Those were just 2 marks. Then you can follow the recording will go to I will upload in the website YouTube this week, so you can get your answer what Jane has said. So, discuss the process of conversion of titles from titles issued under the Repeal Lands Act to the title issued under Land Registration Act 2012. So, Jane, can you continue the process of conversion?
I am not clear on all the processes, but I can make an attempt. Once has been gazetted, then you're supposed to create an account in Adhisasa. Then in the Adhisasa, you make an application. So where you will enter the details, the proprietor's details, the title number, and the system of registration. Then you will also upload copies of the title documents. Then they will be verified by the land registry. Then once they are verified, I know in theory it is a small process, but in practice it's a very long process. So once it's verified, they will confirm whether it is ready for, whether they will have converted. Once you have paid the prescribed fee, then in the system, they will notify you that now that parcel has been converted. Then they will require you to surrender the old original title documents so that you can collect the new documents that are now registered under the land registration.
Okay.
That's all I remember. Yeah.
Okay, that's a good attempt. My laptop here is misbehaving. Now I can't see the screen. Inaanza to misbehave, but the conversion of title process is online, and you can go online. You Google and you get the process. Is under the Lands Ministry. Your process, all the process that is there, and which laptop is misbehaving. As Jane have just said. I hope you can hear me, eh?
Yes, we can.
Okay. So, there's a document called Conversion Manual in the Ministry of Lands, eh? So all those titles which were issued before the 2012 Land Registration Act, Akina Registration of Titles Act.
Mulimu, you were breaking. You said the conversion manual, you find it from where?
The conversion manual. The conversion manual, you find it in the Ministry of Lands website. Eh?
Okay.
Which you can read. So what Jane said there, they want to change all the titles. The Land Titles Act, the Government Lands Act, the Registration of Titles Act. To bring them, you are now issued the title under. They were given under the repeal laws. And they gazette the areas that need to convert. That is what you know that your title deed is due for, to be converted. The principal register here in Nairobi. I remember there is a friend of mine who have a property in Isri. He was telling me to look at Kenya Gazette. I see if his area, Isri have been gazetted as one of the places which they need to convert the title. And I told him, no, they have not gazetted. So, The process of conversion begins with the preparation of cadastral maps. Cadastral map together with the conversion list. Showing the odd parcel of numbers of land within a registration unit and their corresponding sizes. Then, upon receipt of cadastral maps and conversion lists from the registrar, the cabinet secretary in charge of land, in line with the regulation 44 of land registration units order 2017, we notify the public through the Kenya Gazette or newspaper circulation of lists of old parcel numbers and new parcel numbers after conversion. The Gazette notice will specify the date in which the large registry shall open to the public for transaction. Generally, this is what we are saying about the gazettement of areas and all the old parcels. Then the registrar will then issue notice, invited registered owners to make application for replacement of title documents for cross registers. So you make the application accompanied by the original title, PIN, and ID. The registrar will then replace the title deeds with the new ones and retain the old title. That is the process, and you are going to earn 5 marks. So you start by gazetting the gazettement of the area, the old parcels by the registrar, and saying that he intends to close these old parcels of land and open new one. Then he invites people, you make an application, you give the old title, and you get a new title. So we go to the next question because of time. The title to King's family home is encumbered by a charge in favor of Baraka Housing Finance. How will you convince Baraka Housing Finance to release the original title? for purposes of conversion. What do you think? I can see now we are on the 2. We can, okay, Jane has now joined us. Jane Jerry. So Marianne, what do you think?
The advocate for Kim's family does a professional undertaking to the chargee, to the chargee's advocate, assuring them for the title documents and assuring them they'll only use them for the purposes of conversion.
Because you must hand over the old title. Well answered. We go to question 5 because of time. Ocean Limiters are develop a block of 40 flats on their parcel of land known as Kilifi, Kibala, and 330 located in Kilifi County. The flats have a beautiful view of Indian Ocean, and the company is proposing to sell off some of its interest in the property. The directors of the company have approached you to advise you on the model between fractional ownership and sectional ownership, which would be appropriate. Discuss why would you prefer the model. So I think what made this paper to be a difficult paper, making students not to pass, was this question here. The question question 3. Question 4, which we have discussed. I think if this is a question that I've not been asked again about conversion. Question 2 and 5 is a new thing that is just happening the other day, and also now this thing of fractional ownership and fractional ownership and sectional ownership also make this paper to be difficult, because it's the first time they were asking this thing about fractional ownership. And even me, if I was doing this paper, it could have given me a lot of difficulty. So, Marianne, can you try? What is fractional ownership?
Fractional ownership is where you have the like many unrelated parties that usually they own a high risk, like they own a high risk asset, like for instance, like an expensive jet. So they do this so that they can reduce the risk and share like in the expenses for it. Something like that.
So can anyone answer? Also add anyone, you can, Ruth or Jerry, can you add anything on what is a fractional title?
What I can add, there's also the time share where you like you decide like how long does each person occupy the property and when.
Yes, that is it. So the question, that one you can also look at online. You can do your research and get well, but you have stated generally it's ownership of property by many people, and also they share the cost, and also the time each and every person occupies, maybe 1 month, 1 week. So if you're a developer, Why would you, if you're a developer, why would you prefer one model over the other after you have defined? Of course, sectional property, we know what it is. What do you think, Jerry?
Fractional ownership would be more advantageous in comparison to sectional property because so many people can own the same property as opposed to a sectional title, because a sectional title, let's say it is this flat, let's say we are making reference to flat B. Flat B for sectional property has only one owner for the lifetime. For example,
let me cut you short. You are advising the directors of the company, the developers, eh?
Yes.
So what do you think? Why would you prefer one model over the other? Eh? Continue.
For fraction, I would say the possibility of getting more returns because they can have many owners in the same apartment, and then again in fractional ownership, this developer would have a lot more control as opposed to the sectional ownership.
Ruth, what do you have to say?
Personally, I would prefer the sectional property. First of all, at least I'll know the owners because I'm giving a portion, selling some of the units, so I know who I'm dealing with, as opposed to one property having like 40 people. I can deal with one person. Even the transfer of creating the certificate of occupation would be easier. The second one is it will reduce my responsibilities because I'll just incorporate a management company that will be dealing with the common areas that these people will be dealing with. And when I sell the property, now they're the ones to deal with the property, not me again. Yeah, that's what I would say.
That is the correct answer. So it's better to be when you are dealing with one person than when you are dealing with many people. And Ruth has just said there were some of the advantages, and we don't need to emphasize on that. We go to the next question. Egla dreams of owning her home. She recently took her first loan and is actively scouting for properties around Kitengela in Kajiado. During the recent visit, she met with Peter, who introduced himself as a land broker in that particular area. Peter drove her around as they viewed several properties as they identified a particular one for her purchase. Egla has approached you for legal advice on transaction to protect her interests. You have conducted an official search on the property and learned that the registered owner of property is deceased and the property is encumbered. Explain what you advise would her in the circumstances. And you also look at 2, you don't answer 2 for A. For 1, taking into account the findings of official search, you advise EGRA insists on proceeding with the transaction. Explain the steps you would be required to ensure registration of transfer in EGRA's in favor, free from any encumbrances. So, this EGRA, I want a home. And she took a first loan. She was taken around Kitengela and Kajiado by that land broker and found a property. This property, you are being told, he did an official search and learned that the registered owner of is deceased and property is encumbered. Explain what your advice would be to her in these circumstances. So, 2 marks. What do you think, Jerry?
What comes to my mind is now
you're advising her this property is encumbered, and also the owner died after did official search.
Sorry, I don't know, but I would say that I would then follow to see whether who the succession, if the succession proceedings have proceeded and they have appointed an administrator, and for the encumbrance, then the encumbrance would then be dealt with to see whether I want to continue with if it's a charge, maybe we would agree to discharge. I don't know.
Maybe you are answering number 4. Now the second one, you have been told this property has folded that is encumbered. You have not been told which is the encumbrance there. And also the owner died after the official search. Now you are advising him and you are giving him 2 marks. So what do you think, Ruth? Advise her.
Well, first of all, the fact that the owner has passed on, I'll explain to them it is a little bit, it will take a longer process because the beneficiaries, they have to go to the court, get the letter of administration, then do the transmission to her. So it will be a longer process. The second thing, I'll explain to her what encumbrance is, and before she gets the encumbrance has to be removed. So yes, this will take a.
Yeah, that's how you are supposed to answer this question. You start by saying that if the registered owner of the property is deceased, that means they cannot transfer. Transfer cannot be done. A grant, they should investigate if a grant has been taken by the personal representative of the land, of the property, maybe wife or children. Then you see also the encumbrances. No transfer can be done if there is an encumbrance, and you have gotten your 2 marks. Now you have advised her that take into account the findings of official search and your advice. EGRA insists now on proceeding with the transaction. Explain the steps you would be required to take to ensure that the registration of transfer in EGRA's favor is free from encumbrance. So you say that you are going to investigate whether the personal representative have they have taken a grant, and if they have not, you help them to get a grant because he's insisting to buy the property. Of course, you negotiate with them to sell the property, and also you ensure you negotiate with them to remove the encumbrance because no transfer can be done. So after the grant is have come out, then you can do the transfer, and you would have gotten your 4 marks. We continue to the last question. Which is, you read, those are the facts there. I'll go directly to the question. Explain to him whether a letter of allotment constitutes a valid title. This is also a new question that has never been tested before on letters of allotment. So, what is anyone can volunteer and say something?
On letters of allotment.
Yes, you are to be told to advise this person.
For part A.
Yes, part A.
For part A, explain to him whether a letter of allotment constitutes a valid title. No, it doesn't, because it's normally like an offer.
Yes, a letter of allotment is an offer. This is where the letter. This happen where the government, national government or county government, want to allocate land. This is conversion of public land to private. So they first of all give you a letter of allotment, telling you to the condition you need to fulfill before you get this. So a letter of allotment is not a valid title. A title supersedes a letter of allotment. And you can go do your research more on that, and you get your answer. Then advise SIBA on the process of acquiring title from letter of allotment. So can someone try?
Okay, I can try.
Try.
Okay. Okay, when you gain the process of acquiring title from a letter of allotment.
Yes.
So what happens, first of all, you apply for them to get a letter of allotment. Once you get a letter of allotment, there's usually conditions that maybe you're supposed to pay this amount of money within 30 days. So once you pay within 30 days, now you get a receipt. I think you go to the land registrar or the land, so that they can give you a letter of grant. I only know 3 steps.
Okay. Go to your, because of time, I will not go through the process. The process, you do your own research. It is there online. The process of converting a letter of allotment, letter of allotment, you get it for it to become a title. And I think, I'm not sure these people studied these things in class. So that's why I was saying this was a very difficult paper. With also this question 6 was very difficult. So that process is online. Finding it is not hard. So master that process because of the future. Then finally, but not least, before we end, your counter have written to Jan demanding that he stops the construction and vacates the client's land forthwith. On receipt of the demand, Mukola has appointed Blue Advocate to prevent him. The question is asking, advise Mr. Simba on which of the 2 documents, his letter of allotment versus Mukola's certificate of title, takes precedence. This is also related to question A. Letter of allotment is just an offer. Certificate of title take precedence because it's the conclusive evidence of ownership. And there is a section that talks about that. I think section 26, you can confirm, Land Registration Act. So that marks our end for the conveyancing class. Next weekend is commercial. We are going to deal with the papers that have not been researched. I'm going to share them, the papers you prepare in advance. Then we are going to continue that way. And I'm happy for the way you have stayed 3 hours. It's not easy, it's a sacrifice for everyone. And I wish all the best in your preparation for, as you continue in your there in class. But don't. Some of these classes are not very, very important. For example, trial advocacy. That one you can read for yourself. Me, when I was in KSL, term 2 and term 3, I did not attend to advocacy and professional ethics. I was doing this research for Q&A. So don't attend just the important classes. And conveyancing is important, criminal is important, civil litigation is important classes. Because also you need to submerge yourself, let me use that word, to share to this revision and drafting. Of course, there are people who are working. So nothing should be of more important now than preparing for exams. So thank you very much. And we can end the meeting there. Anyone who has anything of burning to say? So